let's dig deeper into the process of the mayor's case with the help of Richard Serafini. He's a well-known criminal defense attorney and former Department of Justice Criminal Division senior trial attorney. And Richard, you know a thing or two about corruption cases, very complex. I want to get right into this. This is the mayor we're talking about here. So can you tell us a little bit about what's expected today as he's going through the processing procedures? Do we expect things like a mugshot to happen?
Ordinarily, you would expect a mugshot to happen. Now, I know that in the case of former President Trump, it did not take place. But as a general rule, it would take place. I would guess that there would be a mugshot taken today. There would be the booking process. That was probably what's going on now, where will happen before the mayor actually goes into court. Then once he goes into court, they'll probably shrink what would be three separate appearances into one. There'd be the initial appearance, ordinarily, then there'd be a bond hearing, and then there'd be an arraignment. Now, I suspect that since he's been indicted, he has the indictment, he's reviewed it with his attorney, that there will be no, there'll be release, there'll be no bond, and they'll just proceed to arraign him today.
Richard, playing to your expertise, wanted to ask you how confident the defense is right now. We know that the mayor has maintained his innocence from the very beginning, and we also know that they have said that he's literally a moving target, that he is the victim of politics. If this was your high-profile client, how would you go about defending this?
Well, I think that the statement of saying that it's politically motivated would certainly be something that I would consider at this point arguing. I mean, I think what you want to get across is that you think that your client is absolutely not guilty, that you intend to fight the charges, that potentially they're politically motivated, or another line of argument is that they're just misguided and the prosecutors have made some mistakes. And then once you start to get the evidence, then you can really formulate what's going to be the basis and what's the most likely avenue to try and get the charges, to try and win, presumably a trial, or if there is a mistake, to get them dismissed pre-trial.
On the other side of this, though, in your professional opinion, being a defense attorney, the prosecution, this is a 57-page indictment. This is a high-profile person.
Lots of jail time.
Do you think the prosecution has to be super confident that they have an airtight case to even get to this point?
Yes, I think that as a general rule, when the government is doing public integrity type cases and official corruption type cases, where they're particularly going after a high-profile individual who, in this case, is the sitting mayor of New York. I mean, you don't get a whole lot more high-profile than this. I would tend to think they believe that they have dotted all the I's, crossed all the T's, and have a very compelling case should they need to present it to a jury.
So
I think that we'll see.
Let me ask you this. Of the charges, all of them very serious, but wire fraud seems to be the most serious in terms of carrying up to a 20-year sentence if convicted, a 20-year sentence if convicted. Can you tell us, as a defense attorney, are you just, hey, let's try to plead this down, or let's try to negotiate ahead of time and try to avoid anything?
Well, I think that the first thing you need to do is see the discovery. Because at that point, you need to make a decision as to whether or not the government has a viable case or a strong case or a slam dunk case. And then you make a decision or a weak case. Then you make a decision as to whether you have an avenue of defense. If you have an avenue of defense in a case like this, it may well be worth rolling the dice and going to trial. Because, look, as bad as it is for a sitting mayor or a sitting official to be indicted, it is worse for a conviction. So if you can avoid the conviction one way or the other, that's obviously what you first and foremost would like to do. If that's not going to be possible, then you start looking at the strength of the evidence and seeing what type of potential resolution the government might be open to.
Richard Serafini, thank you so much for joining us and bringing us some insight there. We really appreciate it.